Once again, welcome to another USC Viterbi Startup Garage event. This is a unique event in that it is both a legal clinic, which we usually only do for the teams in the garage. So when we do an open legal clinic, whenever you see that in your inbox or as like some sort of newsletter event, take advantage because it's something that we're doing new, and it's also when it's a very unique topic, which is today's speaker, Anthony Zaller, who we're really happy to have. He's talking about employment law, something that I think sometimes startups either can't afford or overlook, which is a really easy way to make costly mistakes down the line, not just financially, but sometimes operationally and emotionally. So we're really, really lucky to have Anthony today. I'm going to tell you a little bit about him, then I'm going to pass the mic. So Anthony is an employment defense attorney, and his primary focus is on employment law and startup legal issues. He has extensive litigation experience defending not just wage and hour class actions, so groups, but also individual plaintiff cases of misclassification of exempt employees, independent contractors, IP issues, and unfair competition. He also provides advice and counseling to employers regarding difficult employment issues, hiring and firing, and also complying with the very complicated employment regulations here in California. So if you're a startup who's looking to bring in an intern or a full-time employee or a co-founder or whatever, this is a really great talk for you to learn about how to avoid making some simple mistakes that might actually hurt your company down the line. Thank you so much, Anthony, for being here with us. I'm going to let you talk a little bit more about yourself and kick off the event. Thank you, everybody, for coming. We will do kind of questions throughout the presentation. I'm going to just follow your lead, Anthony, but go for it.
Great. Thank you very much, and welcome, everybody. Honored to present today. And yeah, I'm open to fielding questions on the fly. I've got some slides. I'll make those available to everybody after as well, so don't feel like you have to copy the slides down or anything. We will share those, and it is being recorded, so you get to see the recording later. But today I wanted to cover these top 5 employment law mistakes startups must avoid, and it might be a little different talk than what you might have heard before from other lawyers talking to you. I will be getting into some of the IP, intellectual property issues, and confidentiality agreements. But I want to bring it back a bit too to some employment law basics that I see startups sometimes not pay as much attention to as they should. And generally, I get brought into the equation when a startup has raised some money. And if you're working out of your garage, you don't have any other employees, you're not a huge target. But once you raise $1 million, now all of a sudden you are a target and you have some liability. Or if you have liability, you have the means to pay it. And your investors are going to want to make sure that their investment's going to you to help you get to the next stage of your company, not pay out employment lawsuits or settlements. And that's where I'm generally brought in at that early stage, once some money starts getting raised, just to make sure that the companies have the employment law issues buttoned up. And so I'm going to go over these 5 issues that we see, and just flag the issues for you guys. And it's going to be a very high level. If you have any questions, obviously we talk about it today, but I can help after the call today too. We can discuss it. Here's my information, and I am an employment litigator. So my bread and butter is going to court and defending employers. Actually, I'm in a mediation today. I just stepped out of the mediation. We're doing them on Zoom, which makes it available for me to do this presentation here. I just stepped out, have another attorney filling in during lunch here while I'm doing this presentation. But we're litigators, so any kind of employment issue that comes up in California, we basically deal with. And then we've got a little niche. I've been advising some startups, and I'm involved with the Pasadena Angels as well. And but you name it, though, employers across the state of California, different industries, we represent them as well, from manufacturing to aerospace to a little niche with restaurants as well. So yep, so we've covered a lot of different industries and seen a lot. But for the startups, though, these 5 topics that I have on the slide are some of the pitfalls that we see, and just going to walk through this and go through some of the more common issues that I see come up in the startups scenario. So first, walking through the employment lifespan of an employee hiring pitfalls. What are some common issues here? And once you start hiring employees, you need to really sit down and think about how to bring the employees on properly and put that thought into it up front. There's a lot of documents that are required under California law and federal law, for that matter, that you have to provide to an employee. And I've got just a list of some of them here. And here in California, it's actually becoming very complicated. So for our clients, what we normally do is put together a hiring packet, a new hiring packet, so that we don't miss one of these forms and the employees not filling out some portion that they need to fill out. And there's quite a bit required, as you can see on this slide, for the new hires. I've got this QR code that you can scan, and it takes you to a document we've created with some links to those required documents. And I also put up a sample application for employment and also an end of employment checklist. So when the employee is leaving, what do you have to provide the employee? There's actual documents you have to provide an employee as they're leaving the company as well. So I've got that here on this site if you scan this code, and we will make these documents available after the talk here today too. So getting into some specifics though, offer letters are key. Well, let me back up. During the interview process, I do like having an application, and now I could see a lot of startups saying, well, we're hiring for these sophisticated positions, a programmer or something like that. They're not going to fill out an application. I generally like to have the application in some format, and it's going to help the company. One, it's going to keep a record of who's applying for the job, which you need to keep. You should be keeping those records to show who's applying and who you turn down, just in case one of the applicants sues later on. An applicant can sue an employer if they were not hired and they believe they were passed over for a discriminatory reason. So these applications are just a good means of tracking who's applying to the company. And even apart from the legal justification for keeping them, they're good to see who's been applying and the level of applications coming in too. It's just a good way to track those numbers, and you can go back and look through those. But it's on the legal front, it's good to have those applications filled out, because those employees are attesting to certain information on those applications. And you can have the employee sign those applications saying, look, everything that I've told you in the application, on the application, and during the hiring process is true. And if that turns out not to be true, employers can go back and rely on that when they're defending litigation, saying, hey, look, if the employee had actually been truthful on their application, we wouldn't have hired them. And it cuts off some damages in employment lawsuits sometimes. So I do like having these applications, and it's just clearly having the employees putting that information out to you and saying, hey, this is true. And to the extent it's not true, it's going to open up some legal defenses for you down the road. Now, getting past the hiring process, and you've got a new hire coming in, I recommend at the minimum having an offer letter. And I've got the elements of the offer letter that should be spelled out for all employees. And here in California, most employees are at-will employees. Under the labor code, they're presumed to be at will. So that means that they can be terminated or fired for any reason at any time just not for any of the illegal reasons, such as their race, gender, national origin, sexual orientation, those categories that you all know about for the illegal reasons. But it's good to preserve that at-will designation and make that clear in these offer letters to the employees. And I also recommend putting in the offer letter the employee classification, whether they're exempt or non-exempt for wage and hour purposes. So exempt means they're exempt from overtime or exempt from the labor code for certain provisions, such as paying overtime. You don't have to pay an exempt employee overtime. Non-exempt employees are hourly employees, traditionally referred to as hourly employees, where you pay them by the hour. If they work that hour, you have to pay them. And then in California, we have to pay overtime for anything over 8 hours in a day or anything over 40 hours in a week. So it's good to set that up out front. And at the bottom of the slide, I've got this caution about a choice of law provision in any type of documents you give to employees. And we'll be talking about this when we get into the intellectual property assignments and agreements as well. California has said, look, we've got very specific laws that protect employees, and we don't like when employers try to get around those laws. So we're not going to recognize an employer putting an agreement together for an employee that resides in California and then saying, oh, by the way, Texas law is going to govern this agreement or this non-compete. And it's called the choice of law provision. And this labor code section 925 prohibits employers from doing that. And so if the employee resides here in California, employers can't have this other choice of law provision, taking the law or applying law from outside of California to the employment relationship or to that employment agreement. And we'll talk about that here in a little bit too, in a little more detail. So I also recommend an employee handbook, having that set up once you start bringing in employees. Should consider arbitration agreements. I generally like arbitration agreements, but it's not something that companies should automatically implement and bring into the employment context just automatically. There's some pros and cons to it. Some pros with arbitration agreements is generally arbitrations are much more confidential than if there's a lawsuit in downtown LA where all the records are public documents. So you can keep a lot of the issues more confidential. I'm not saying it's totally confidential, but you've got more of ability to restrict what information is getting out there to the public in an arbitration. The major con with an arbitration is that the employer has to pay 100% of the arbitrator's fees, which can be quite expensive. We've had a 4-day arbitration last year or a couple of years ago now, prior to COVID. A 4-day arbitration, they're running about $30,000 to $40,000 just for the arbitrator's time. So they can be expensive, but I think for some of the benefits, primarily confidentiality, it could be worth it. You also have to remember about the sexual harassment training here in California. It's required for most employers. If you've got more than 5 or more employees, you've got to be doing the sexual harassment training for the employees as well as supervisors, a 2-hour sexual harassment training for the supervisor and 1 hour for all the employees. And it has to be completed within 6 months of promotion or the hire date. And I do also highly recommend the IP ownership agreements. And then I've got questions on these last 2 items, the non-competition clause and non-solicitation clauses or agreements. And we'll talk about that here in these next few slides. I've got question marks there because here in California, those are tough to enforce, just to be upfront with everybody. Really tough to have a non-competition agreement with an employee of your company, but we'll get into the details here. So getting into the intellectual property ownership agreements and other considerations, the non-competition, as I mentioned, generally unenforceable under California law. There's a California Business and Professions Code section 16600 that basically prohibits non-competition agreements here in California. And And again, as I mentioned, under Labor Code Section 925, California won't allow employers to go out and apply some other state law to an agreement here in California that and a lot of other states do allow the non-competition agreements and clauses to exist, but not here in California. And you can't go out and grab one of those other state laws and say that's going to govern your relationship with an employee that resides here in California. So the next question then, well, if I can't have employees enter into non-competition agreements, can I have them enter into non-solicitation clauses that they won't solicit employees from the company should they leave? But generally, they're unenforceable here in California. And I've cited this case that just came out recently. I think it was about 2 years ago, the AMN healthcare case that said basically the 16600 section bars any restrictions that prevent people from engaging in their profession, trade, or business of any kind. And if these non-solicitation clauses are drafted so broadly, it's going to prevent them from doing their business. It could violate that section of the Business and Professions Code. However, the last bullet point here on this slide, the company can still protect trade secrets. So usually there's litigation over this issue on whether the employee is taking a trade secret, and where it comes up on the non-solicitation clauses is client. So is the client list confidential? Other aspects or other information of the company that are trade secrets, and they are protected. Trade secrets are given force under California law, and employers can protect the trade secrets. But I have a warning here that the information does have to be a secret. Oftentimes I'm approached by a client saying, yeah, an employee stole a trade secret. They have our client list. And then I look at the company website and all the clients are posted on the company's website. So that wouldn't be a trade secret. So if you're going to try to rely on this trade secret and protect trade secrets or confidential information, it has to be confidential. Steps within the company have to be taken to protect that information, and it can't be distributed widely within the company either. It has to be given to people only on a need-to-know basis. So if you've got a trade secret or confidential information, you need to make sure that it's protected, and you're putting measures in place to protect that information. Any questions? Let me see at this point. I see a few coming in on the chat, but feel free to interrupt me or Sal.
Yeah. So I'll say that there's been one question in the chat from Fabian. Fabian, would you be comfortable turning on your camera and asking it yourself, or you want me to field it for you?
No problem. I was just curious, you mentioned the at-will offer letters and at-will contracts. I'm assuming if the employer can let employees go at will, the employee can also leave at will without consequences. If that's right, would you recommend them maybe not having at-will contracts in certain circumstances? Let's say you want to keep an engineer for a certain amount of time. Thank you.
Good point. Good point. So generally, most employees, I'd recommend keeping the at-will designation. It gives you a lot of flexibility to terminate somebody if they're just not performing. If you can't put your finger on exactly why they're not working out with the team, you can just let them go. And I like to have that flexibility. But you raise a great point where if it's a key employee, and oftentimes you see employment agreements with high-level executives, the CEO, the CFO, somebody that is very unique, that it's very hard to hire for that job. Then you do an employment agreement, and then it's not at will anymore. You've got an employment agreement where the employee can quit only for specified reasons or with certain notice to the employer, so that the employer can have a couple of months time to start planning for that employee to leave, to gather everything together. And likewise, the employer then can't just terminate the employee if they feel like it, or even if for cause. That's usually spelled out in those agreements. And there's notice periods between that the employer would have to give to the employee before they let him go. as well in that case. So if it's a key employee and they're like one of few people that you actually know that they can do that task, it might be something to look at, but I wouldn't go into those agreements without help from a lawyer. They get very complicated, and you need to define these terms. What is a for cause termination, and what if the employee is just not performing? How is that going to be dealt with? And you need to go through that, and it's very detailed agreement, and you need to spell that out clearly. So work with a lawyer on that, but a good point.
Great.
RC, I have a quick question.
Yes, I don't know.
Hi, Anthony. This is David Gerber here.
Hi, David.
Okay, thank you so much. My quick question is, how do you, in a sense, protect trade secrets? Going back a slide. Just a general answer would be helpful.
Yep. So in a simple scenario or example would be the Coca-Cola secret formula. It's secret. It's kept under lock and key. Only certain people know the formula. And from my understanding too, only certain people know part of the formula. Not everybody knows the entire formula. So it might be distributing information so that only a very few people within the company actually know how to put the whole trade secret together. And if you start, so it's really what steps the company is taking to protect it. So one, who you're sharing it with. Two, what measures are you taking to keep it secret? Is it, if it's code, for example, is it encrypted? Are you maintaining it offline maybe? And the more that you can point to on these security measures that you're taking, the better you're going to have, the better argument you're going to have that it's an actual trade secret.
But you can't just say, for example, at the very early stages of an idea, say this is a secret and private and confidential on your deck, or telling people in writing this is considered a trade secret. Does that count?
Yeah, that would help for sure to have that. But again, if you're sharing it to just any investor that shows up and say, hey, we have this trade secret, that's going to potentially go against your argument that it's a trade secret. You're still sharing it with the public. Now, if, yeah, so it depends on the scenario, but the more steps you take to protect it, the better. And it's good to put that, it's a trade secret in the agreements or on the document, but watch who you share that document with. And the more you can do to, designate it as a trade secret and lock it down, the better argument you're going to have. Does that answer your question?
Yep. Thank you very much.
Sure.
Great. Might be it. I'd just like to remind everybody, in case you don't know, the hand raise function is at the bottom of the screen under reactions. It's probably the easiest way to get your question answered. If you do put it in the chat, I'll keep an eye out though. Okay, sorry.
Great. No, that's great. I like the back and forth like that. So feel free to jump in. So I do recommend having the IP ownership agreement with the employees. Now, I split these next few slides up between employees and contractors, independent contractors. There's different standards that apply. In this slide, I'm talking about the common law. That common law was just in court law made, and there's general principles in common law here that I set out for employees. And generally, courts have said in the U.S. legal cases going all the way up to the U.S. Supreme Court have said that whoever invents, and this is the default, I think most companies should just put in their mind when they're dealing with this issue, and this is the way investors are going to approach the issue, is whoever invents or writes a material or comes up with something owns that. So if I think of an idea, it's mine as long as I have possession of that. If I came up with the idea, it's mine. And the U.S. intellectual property system is built on this doctrine that whoever invents it owns it. And what companies now are doing, and courts have said, companies can contractually get around this common law doctrine that whoever invented it owns it, and people can start assigning their rights to companies. But it's the exception to the general rule. So now the common law has also recognized this hire to invent doctrine. And that's basically saying if the employer hires someone to design or come up with the product, the invention belongs to the employer, even if the employee comes up with a new or novel idea on how the invention might be built or better designed or produced. So if you're hired to invent, work for hire, then the employer generally owns that. But it's this common law doctrine that, and it gets a little gray if you start getting into that doctrine and have to rely on that doctrine. And that's where these IP ownership agreements will come into play. And you can clearly spell out to the employees and the contractors of who owns the intellectual property under what circumstances to protect the company. Now you hear about shop rights sometimes as well. And again, this is a common law doctrine that if the employee has come up with an invention, but used business time and materials to invent, but it was unrelated to why the employee was hired, the employer would have this shop right to basically a license, a royalty-free license to use the invention. But if the employers or the company's going back to these common law doctrines, it's going to be a little gray, and it's tough to rely on those to establish ownership over the intellectual property. So the law here in California, in the US, has said the employees can assign their intellectual property to companies, and this can be modified by contract. So that's where most companies, they need to look at this and have these invention agreements and trade secret agreements in place with the employees so that it clearly spells out who owns the inventions and how that's going to be dealt with under these different scenarios that come up. So the agreements are detailed. I've got some examples. I haven't shared those with this because I was a little nervous. I want to walk you through some examples. If anybody wants an example, reach out to me and I'll walk you through that and tell you about some different issues that come up in the agreements. But companies need to have these in place. Investors are going to be looking to the company to make sure that these are in place as well, so that there's a clear chain of ownership of those ideas. And if you don't have these agreements in place with the founders, with employees that come on board, it's going to raise a lot of red flags with the investors, because the investors might say, well, if we have to go back to common law doctrine and try to prove ownership, it's not going to be worth it. And there's a lot of gray areas. So these agreements are going to be key for investors. Now, under California law, the contractual assignments, I've got these statutory restrictions set out here. Under California law, an employer cannot require an employee to assign rights to inventions that are unrelated to employment. So these are, for example, inventions that the employee develops entirely on their own time without using company equipment, supplies, facilities, or trade secret information. And it's also important to note that to the extent an employment agreement violates this prohibition under California law, the agreement is void and unenforceable. So employers need to be careful that it doesn't overreach as well. The contractual assignment doesn't overreach. It could void the entire agreement. So be careful about what language you have in these agreements. Have a lawyer take a look at them. And again, to the last bullet point, the courts, California courts and the statutes don't like when companies try to have an employee say that basically after they leave employment, whatever they come up with for inventions after they leave employment, that's going to be the intellectual property of the company. Courts and California statute looks down on those types of agreements. They're very tough to enforce and generally unenforceable under California law. Now, in terms of independent contractors, the ownership agreements, unlike employees, there is no presumption that a company owns the property that an independent contractor develops. So the courts will look to an agreement to see if there's a work made for hire, and therefore then it's the company's property. So it's even more critical to have these assignments and agreements, intellectual property agreements, with contractors when you're outsourcing this type of work, to make it clear that the company owns that product that the contractor is hired to make. So some other common issues that come up in this context too, that companies need to pay attention to, and investors will look to when they're investing in a company, is the development of IP while working for a prior employer. Is that going to raise any issues? Does the prior employer have any right to that intellectual property if that employee has left and tried to start a company with some of that IP? So investors and the attorneys will look at the prior agreements that employee or the founder worked with or entered into with the prior employer. That could be an issue that needs to be dealt with early. And also, it comes up with this pre-incorporation inventions. So let's say the company isn't incorporated yet. Everybody's kind of working. It's just a handshake, some friends working on an issue, and we're coming up with some inventions or some code. Once the company is incorporated, that needs to be assigned to the company. We can't just start the company and dealing with it. Even if it's the founders, it needs to be assigned to the company and documented in some manner. And then also the final point is not having all workers sign a confidentiality and invention assignment agreement once incorporated, and keeping these up to date and cataloged properly, so that we can show investors that there's a chain of ownership on the ideas, and that everybody that has been hired since the company's been founded has signed one of these agreements. So I've got a few best practices here set out on this slide. I won't walk through all of them, but the couple takeaways: work off checklists. Don't just go into this without any plan. Develop the checklist. Make sure that your hiring manager, if somebody else is doing the hiring, is working off the checklist to make sure that everything is signed off on. All the documents, same documents are provided to all the new people being hired by the company as well. And develop a system to keep these and maintain these documents. So if investors ask to see them and there's a due diligence, we're not pulling together a lot of separate files or going through people's emails, inboxes to pull it together. Set these systems up early, and it's going to save you a lot of time in the long run. Now, some non-discrimination considerations in the hiring. I kind of went over this already, but during the hiring process, employers generally can't ask questions that are going to reveal characteristics protected under the law. So, these traditional protected categories. And in California, there's a lot more as well. So be careful. Make sure if you're hiring or if you assign the hiring to somebody else within the company, that they aren't asking questions that could get into this type of information. And you have to be careful too. Some seemingly innocent questions could lead to whether the person is, for their age, what year they graduated from college, things like that, whether they're married, whether they have kids. Stay away from those types of questions. Now, if it just innocently comes up, the employee or the applicant brings up some of that information, it's not illegal to talk about, but I would generally stay away from that so that the applicant can't make the case that the employer relied on that in not hiring the applicant. And I saw a hand come up, so we could jump
good.
into it.
It's curling. Go ahead.
Sure. Yeah. Thanks, Anthony. Even though I was at Viterbi for computer science, I was pre-law, so I love talks like this.
Right.
I know this is really focused on hiring and new hires, and I have some questions for that later on. But some of our startups are actually getting kind of like advisory boards. How does that relate with that, having an advisory board member and things of that nature with some of the ideas, kind of like some best practices maybe?
Yeah, that's a good question. And I didn't prepare any slides for that, but
Sure.
Off the top of my head, some ideas that come up though. Advisory boards, would I have an agreement with them? Potentially, it might be worth having an agreement with them, spelling out what that looks like. And I've dealt with some startups where it actually turned into an issue where the company thought somebody was coming on as an advisor, but then the person turned and said, hey, you owe me wages because I was an employee.
Yes, I seen that.
Yep. So I would have that spelled out with the agreements. Just documented, like, here's your role, here's your duties. I would probably build in this confidentiality as well. So have that addressed. So, as an advisor, you're going to be learning some trade secrets and confidential information. You have to keep that secret. And then spell out what compensation, if any, they're going to get. And if they're not getting any, just spell that out clearly and set that role out.
Anthony, related to Curling's question, have you ever advised to use the FAST agreement for advisors?
So it depends. And, it's been a while since I've looked at the FAST agreement too. So I'd have to look at it. But so off the top of my head, just blanket agreements make me nervous. With that said, it shouldn't be that much work for your lawyer to put these agreements together, half an hour to an hour. And I think it's worth that cost to have that put in place for your company. Now, I understand there might be some financial concerns. You can't get the lawyers involved, but reach out to me. And when in doubt, if you've got to pull something together yourself, I think you're all pretty educated to put something. I think it's better to have something in place than not having anything at all. Would help a lot. So, but it's been a while since I looked at the FAST agreement, though.
That's good feedback, even David. That's good feedback. Thanks, Anthony.
Yeah, but I'll take a look. I can follow up with that too at the agreement and give some feedback on that. Some quick pointers here too. Here in California, we can't ask about salary history. So generally, what you can ask here is just applicants. What's your expectation for salary, and that's how you deal with that. But it's an issue that comes up sometimes that employers or hiring managers might not know about. And then background checks in the hiring process raise a lot of questions here in California. California has a law, and actually Los Angeles City and some other local cities, San Francisco has a prohibition on some background checks as well. So if you go into doing background checks or credit reports, go into it knowing that you've got some legal issues to deal with, some disclosures to make. And sometimes you can't do them. It depends on the position you're hiring for, if you can do them even or not. And then finally, social media searches, be careful. It's okay to do that. It's a public, it's out there in the public, but be careful what you're relying on. And then California law also prohibits employers from asking applicants to disclose passwords, which I don't think is a common practice, but I thought I'd throw it out there today.
Anthony, we have one more question from Riza.
Sure.
Hi, Anthony. Thank you very much for the great presentation. I have a question about deciding between having a contract or hiring people to do the same job. So is there a rule of thumb you think that should be considered between these two routes?
Yes. Great question. And I've actually got some slides on it. So if you could hang in for these next two slides, and then I'll jump into that and give some feedback on that. So that'd be great. So some documentation, just reminders here. You need to be keeping these documents for employees. And again, setting up a system to maintain these documents. So applications, other hiring information, even if you don't hire the person, you should be keeping these for at least 2 years. Job ads, hiring and personnel information, you should be keeping a record of these for at least 1 year. And then the I-9s, you need to have those in a separate file, 3 years from the employee's date of hire, 1 year after their termination, whichever is longer. And then there's some wage and hour documentation as well. So, the big thing here, just keeping payroll records, time records if they're hourly, and a copy of the employee's pay stubs. And don't just overlook this. It comes up a lot. I'm dealing with it quite a bit. And I know you've got a lot going on when you're trying to start a company, but keeping these records and having somebody in charge of it and not relying necessarily on your if you do have a payroll company, be careful. They won't keep these records going back too long. And then if you switch payroll companies, they're just going to delete it anyway. So it's good to have your hands on these records and maintaining it yourself. Now, getting into some of the wage and hour issues and hiring employees and how to classify them. Let me come back to this one. I want to address Reza's question about independent contractors versus an employee. This is a major issue for startups. And generally, I see the startup saying, we'll just hire everybody as an independent contractor and deal with it later. And it raises a lot of issues and under California law. So the burden is on the employer. If you hire or treat somebody as an independent contractor, the burden's on the employer to prove that they're an independent contractor, not an employee. So the presumption going into it should be that they're an employee. And I've got the risks here. It adds up quite a bit to this SB 459. There's a penalty of up to $25,000 per violation for a person that's willfully misclassified as an independent contractor. And there's potential personal liability for the founders as well. So what's the test on whether you can classify somebody as an independent contractor or an employee? In California, generally the test comes down to this ABC test. It's relatively new. Now it depends on, there's different tests out there depending on different reasons that you're looking at for the classification. But here in California, generally the ABC test is going to apply. And I've got the 3 factors that are set out in the ABC test here under California law. So A, the worker is free from the control and direction of the hirer in connection with the performance of the work. So basically, A is that the employee or the worker, the independent contractor, is free from any kind of direction and control. The company is not directing the worker on how to do their work, where to come to work each day, setting schedules, what to work on. If they're hiring them, saying, take care of this problem, and the contractor takes care of the problem. Element B is that the worker performs work that is outside the usual course of the hiring entity's business. And I've got this highlighted because this is really the prong that catches most employers, and where most independent contractors would be considered an employee under this prong because they're generally in the usual course of the hiring entity's business. They're performing work in the hiring entity's business. Now, this is the prong. I don't know if you've been following for Uber and Grubhub, these types of third-party delivery companies as well, and taxi companies. They've been hit on this independent contractor versus employee for the drivers. There's a lot of litigation across the US, and this is really the prong that's holding them up. Now, Uber says, look, we're not in the business of hiring drivers. We're in the business of technology. And we've developed a technology to enable drivers to do this, this ride share. Now, the employees are arguing, no, you're basically in the business of providing rides to people. And because these drivers are in your usual course of business, the hiring entity's business, these people should be treated as employees, classified as employees, not independent contractors. And then C, the final factor is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So this is where the workers got their own business. They're holding themselves out to other people to do work for other people. They've incorporated their own business, things like that. So it's a quick overview of the ABC test, but that's what it basically is going to boil down to. And most employers, if you're going to have an issue, it's usually under the B prong of the ABC test. Great. And then the other issue that comes up when hiring somebody is classifying them as exempt or non-exempt. Now, we can't just hire an employee and give them a straight salary and not pay overtime and just assume everybody could be treated as exempt. We see this come up quite a bit in the in the startup scenario. So generally, though, the burden again is on the employer to treat an employee as exempt, straight salary, where they're not owed any overtime for working overtime. The burden, the assumption is most employees are non-exempt. They need to be paid hourly and paid overtime if they work more than 8 hours in a day or 40 hours in a week here in California. Now, employers can show, if they meet the burden, that the employee class qualifies as an exempt employee. They could show that, but to do that, generally, the employer needs to show that the employee performs duties for more than half of their work time, high-level exempt duties. So hiring, firing, helping you manage the business, things like that. And if they do more than half of their time on these high-level duties, that meets one half of the test to qualify for exempt. The other half of the test to qualify for exempt nature is that they are earning an annual salary. And oftentimes for many of the exemptions, it's 2 times the equivalent to 2 times the state minimum wage. And in 2022, that's $62,400 per year for employers with 26 or more employees, and $58,240 per year for employers with 25 or less employees. So they have to be earning a salary, this guaranteed salary of at least that amount as a threshold issue, so that they've got to be doing more than half their time performing high-level duties, and 2, they need to be meeting those threshold salaries too to meet the exemption. Now, there's a number of different exemptions under California law that could apply. So if you have any questions, let me know. This is kind of a quick overview, and don't go into this classification though without thinking about it and knowing which exemption the employees fit under. Now, some other considerations: timely payment of wages. The employees, there's under California law, strict requirements on when wages need to be paid. I've got those set out here, basically twice a month, and there's certain time periods required on that. And also there's timing requirements. So if an employee is leaving the company, they either give notice that they're going to leave or they're fired. There's strict timing requirements of when they need to be paid all of their wages. So if they're terminated without notice, if they're terminated, they need to be given their final paycheck plus any accrued and unused vacation at the time of termination on their last day. Now, if an employee gives notice of at least 72 hours, then they have to be paid all their wages, including the accrued vacation, at the time they quit. And then if they don't give 72 hours and they quit on the spot, they come in and say, I'm quitting today, the employer has 72 hours to make all final wages paid to the employee plus the accrued vacation. And then I just brought up on this slide the final point too, just to keep in mind, we're seeing it come up more and more, expense reimbursement claims for business costs. Under Labor Code Section 2802, employers have to bear the costs, all business costs. They can't shift these costs onto the employee. And where we're seeing this come up is the use of cell phones and other technology. If the employee is using their cell phone for business purposes, the employer needs to be reimbursing the employee for those costs. There's a case that came out on that that made that clear. Now, the court didn't describe on how the employers are supposed to do the calculation for an employee that's got just a unlimited data plan on their cell phone, and they use their their cell phone for work purposes and personal purposes, how to do that calculation. It's a bit of a gray area, but employers need to be thinking about this and have some type of agreement. If the employees are using their cell phones or other personal equipment, there needs to be something paid to them per month, reimbursing them for those types of costs. And I see a hand coming up here too.
Me. I actually was wondering if that is also now in this kind of more remote work environment, including like internet service.
Yes.
And then, and all the video equipment that goes along with that.
Yes.
I know at least for a period of time, the university that I work for, which is so great, was ahead of the game and was realizing that work from home is exactly what we needed to do. And so then there was a kind of like a cost that went along with that was added to our income, which was really nice. However, the idea was that it's temporary because the pandemic is temporary, but I think we're starting to see that businesses are moving more towards remote work anyways. So I'm wondering.
Yep. No, it's a great question. And I think it comes up with a scenario of, is it required by the employee? Is the employer requiring it by the employee? And then if it is a requirement, the employer has to pay, a pro rata share of the costs. And that's a whole nother question, how to come up with that. But so for example, in your scenario, I think if the employer says, look, we don't have an office, nobody works at an office, everybody has to work from home, that's going to trigger these issues about internet, cell phone, things like that. There should be some costs allocated towards that to the employee to reimburse them for that. But now on the flip side, if the company now says, hey, COVID's over, we're all coming back to work, come into the office, and then the employee says, yeah, I don't feel like coming in and I've got some childcare issues and I'm not going to come in. Is it okay if I work from home? Now, all of a sudden, that flips the scenario where it's not a requirement by the employer. It's more the employer accommodating the employee's request to work from home. I think there's an argument there that the employer doesn't have to pay for those costs because it's the employee's choice at that point to work from home, and it's more of an accommodation for the employee. So something to think about and approach it. And I flagged it just because we're seeing the cell phone issue come up in so many different scenarios. In restaurants, we're seeing it come up where employees are doing scheduling on their cell phones, and the restaurant is not even thinking about any kind of reimbursement issue on that. And there is some cost associated with that under this case that came out. And arguably, it's a very small cost, but something should be allocated to the employee for that reimbursement. And I've got some slides here. We'll move through it quickly. Just to keep in mind for your hourly employees, your non-exempt employees, there's meal break requirements under California law. There's also rest break requirements under California law that should be set out in the employee handbook. And it might sound ticky-tacky that I'm bringing it up, but we see the litigation on this a lot here in California. And when I'm done with this, I'm jumping back into a mediation for a case. They had a few hundred employees. The opening demand for the mediation was in the millions of dollars on this meal and rest break case. Yeah, so it adds up quickly. So be careful, keep an eye on that, and don't overlook those simple things to set up early. Now, avoiding the discrimination and wrongful termination types of claims. Quickly, just to go over some best practices here, just staying compliant with the law. Documentation is key here, documenting employees' performance. So if you're letting an employee go and they haven't been performing well, there's some documentation you can point back to establish that. Now, does it have to be a formal write-up on some formal company letterhead or formal company write-up? It doesn't. It can be an email to the employee or a series of emails to the employee, but be careful about documenting it. So if you talk to an employee saying, hey, your performance is not up to par, a good way to follow up on that is just send a follow-up email saying, hey, I just wanted to follow up. Thank you for our discussion today. I raised these issues, you raised these issues, but, just as a reminder, you're going to have to step up on these certain issues. Let us know if you have any questions going forward. That's a great email to have. And if there's litigation that comes out, I, as a litigator, like having those emails versus having a he said, she said type of recollection of who said what during what conversation and when that was brought up. Curling, I think you've got a question.
Yeah, it was on more that wage, like pay stub, time requirements. One of our later stage companies, they're like around like 20 million like ARR. They just had to go litigation because of like that type of thing, not having the manual, not having all these things. They just finished up. We had a whole talk with the cohort on that. But is there any other like best practices on that? I know we've learned about the manual because of all that, like having this kind of work manual. But is there, or even like a book that I can give some of the startups on just that, since it's fresh in the cohort's mind that happened to a great company, right? But we just need to be more aware of it.
Yeah, and actually I took some slides out of the presentation today dealing with that. I didn't know how
Okay.
relevant it would be for everybody, but I've got some resources I can share
Sure.
and some audits that companies can do to make sure, just flag these types of issues. And once you're over, yeah, I would say once you have one employee, you've got liability, but once
Got
you're
liability.
over the 50 employee threshold, the
Okay.
liability starts adding up to potentially millions of dollars.
Sure.
And it's something you can't avoid. And here in California, you're going to have to deal with it eventually. And so it's something to think about and start planning. And it gets very technical. And again, I hesitate to bring up meal and rest breaks and pay stubs.
Sure.
But one thing off of a pay stub, there's 9 things that have to be on a pay stub. And if you're missing the address of the employer on the pay stub, it's
Sure.
a violation. It could be $250 per employee per pay period for the penalty. So it's something you need to go into with some advice and help. But I've got some resources. I'll share those with you.
I appreciate that, Anthony.
Great. So documentation is key. And then this last point on this slide, for wrongful term claims, considering if an employee is leaving the company, especially if they aren't happy and they've raised some issues, considering offering a severance agreement to the departing employee. And what you do here is you give the employee some extra money, we call it consideration, in exchange for a release of all claims. So you could give them a couple of weeks to maybe a month of pay, depends on how much you want to offer, depending on what types of risk you think are out there for the employee. But you negotiate this while they're leaving, and it's going to save you a lot of money in the long term if you could pick up this release with the employees leaving. It just settles all claims. The employees can release all known and unknown claims against the company for consideration as they're leaving, and it's going to prevent litigation down the road. So think about that. And if anybody is ever in that scenario, or you think you might need a severance agreement, there's some good draft severance agreements. I could help put that together and have that buttoned up, but something to think about in terms of severance.
Anthony, can I ask a quick question?
Yes.
Great. So you mentioned you want to document performance. Is it best practice or is it mandatory to give employees an opportunity to improve before letting them go?
So, well, that's the good thing about an at-will employee. You don't have to give them an opportunity to improve. You could say, look, you're just not meeting our standards. We're going to let you go. You could do that if they're at will. Now, so there's no legal requirement that you do any kind of progressive discipline. It's called progressive discipline, where you have to write the employee up 3 times and then you can fire them or anything like that. If they're at will, you can fire them first offense that they commit, or first time you sense that they're just not performing well. But generally, it is better to show, and just expense-wise too. I mean, it doesn't make sense to just terminate an employee if they're not performing up to your expectations. Coach them, get them to perform better, see if you can manage them into that role better. It's going to be a little more cost effective for the company instead of firing and trying to rehire all the time. So it is good to show that. And then that documentation is going to be better for you to show, like, look, I gave the employee every chance to try to improve, and here's the issues. So if the employee comes back and says, no, it was really because I complained about this illegal practice that was going on, that's why I was fired, the company could say, no, by the way, you never complained about anything. And here's the 10 emails we gave you about your performance over the course of 2 months. And we gave you every opportunity to improve, but you just didn't improve. And here's the concrete examples of how you didn't deliver on the things we needed you to deliver on. That's going to be much easier to defend.
Got it. Thank you very much.
Sure. So this last issue I bring up, and it's just kind of more some thoughts. Founder is HR. Founder is human resources. And I understand your startup. You don't have this huge HR department that you can rely on to put these forms together, document and save all these files. But just some considerations, I think, as a founder, you should be thinking about the HR function. I mean, first, there's nothing that says you need a special certificate to be an HR director or anything like that. There's no special certificate you needed to become an owner of your company or anything. So, this really falls on the founder at the early stages of the company. And as a founder, you need to be well versed on these issues, especially here in California. There's substantial liability. So don't neglect these HR issues and pay attention to them. And it's critical, and I think it's critical with the company culture, setting up a good culture, making sure that you're buttoned up on these issues really communicates to the employees. The company knows what it's doing internally for an internal culture, but also to the investors. At some point, you're going to have to show your investors that you've got this buttoned up as well, and it's going to come into play. So I've got a few ideas here that I set out to think about as a founder, and just some other questions. And I don't have, it's a difficult position, you know, as a founder to have all of this on your plate on top of everything else, but it's important to pay attention to. And as a founder, I think that's what you've signed up for. And it's just key to know these issues and know when to reach out to somebody for help when these issues come through. And I hope I've been able to flag a lot of the issues for everybody today on common issues I'm seeing in the startup scene, that at least you've got an idea. You say, okay, I remember Zaller talked about that, and I need to look into that a little more now and either document the issue more or make sure I'm saving those records properly or setting up this employee classification better. So I've got some resources here. My blog, we do quite a bit of legal updates. One good way to stay up to date, and we've got some podcasts as well. So there's a lot of resources out on the internet if you're not watching our resources. And I appreciate everybody's attention. And if we have time, I went over, sorry, went a little long.
Oh, please. I mean, it's to our benefit that you go over. Also, it's not, I mean, it's important to mention that as an angel investor yourself, you know, you are kind of a unique resource in that you can be on both sides of that support spectrum, right? You're supporting the teams in a way with your general advice and understanding how to be a successful startup internally, right?
Yeah.
And so it is kind of nice to see what it's like to have someone with both of those areas as an expertise. So does anyone have any final questions? I do want to be respectful. I know there's this mediation that you probably need to get back into. Any last minute questions for Anthony? Seems like we're all buttoned up. I want to just remind everyone that our spring cohort is currently live. The application is live. I put some stuff in the chat. I'll also put it in the wrap-up email where we'll have this really nice video. The chat will be there. Anthony has promised very graciously some documents that will be super useful to you guys as startups. And then I'll try to get all of these links as well to your blog, your LinkedIn profile and things so that you guys can stay connected with Anthony beyond this talk. Much appreciated, Anthony. Is there like maybe just some parting words that you can say from just your experience with startups? Something that comes to mind right off the bat?
Yeah, and I hesitate putting a lot into the slides, and I don't want to overwhelm everybody to where it's like, it's so overwhelming you give up on this and just say, well, I'll deal with it later. Just start somewhere. And if you can button up one or two of these issues that we talked about or go into it with knowledge and document it, it's going to save you a lot of time and headache in the future. Even if it's just dealing with investors, if you've got the documentation, you know where to pull it, it's going to save you a lot of time on pulling that and showing the investors that you've done what's right and you've got everything documented properly.
Great. All right, thank you for your time. And then I will be in touch on Monday with the follow-up email, including some upcoming events. So stay tuned, everybody. And thanks again, Anthony.
Thank you. Have a good day, everybody.
Bye-bye, y'all.